Hello everyone, my name's Rodney Gardner. I'm a solicitor that's been in private practice until last year, and my job now is to inform you and help you understand the great opportunities available within the financial irregularity arena. Many firms, of course, offer personal injury services, which are really personal bodily injury services, whereas I'd like to interest you in addition, and in some cases substitution, personal financial injuries that are sustained every day by huge members of the public. I've actually got three distinct legal models. The great beauty about what I'm about to tell you is that they're all interrelated. They all rely upon the Consumer Credit Act and unfairness in the relationship between the creditor and the debtor, and they all have the same blameworthiness factor, which is essentially a failure by the lending industry as a whole to disclose earnings or commissions in relation to financial products. The bedrock model, the one that I have the most experience and have the most established law, is the case of Plevin versus Paragon Finance Limited. Plevin, as it's known for short, was a case that went all the way to the Supreme Court in November 2014 and was essentially concerned with the sale of payment protection insurance, or PPI as we call it. What that established, although it was a long and circuitous drive through all the various courts from the county court upwards, was that there was unfairness in the relationship between the borrower, claimant Mrs. Plevin, and the lender, defendant in this case, Paragon, by reason of the failure by Paragon to disclose that it was receiving or earning substantial commissions from the sale of PPI. That's what made the relationship unfair and allowed Mrs. Plevin effectively to win back all the monies that were in fact expended by way of PPI payments or loan repayments plus interest. In other words, Mrs. Plevin's claim arose because she'd made a complaint under the complaint scheme that ended in August 2019 for the mis-selling of her PPI. This was rejected, and my experience arises from the huge numbers of people who weren't able to get redress or compensation under the complaint scheme. So effectively, what we did was rely upon a principle that had not been established, which was the new provisions as they then were when Mrs. Plevin consulted me in 2008 within the Consumer Credit Act. I don't want to take too much time out of the limited time I have today going into the law too much, because what I would like to do is avail you of the opportunities that are there, both commercially for the law firm to have an additional highly remunerative profit centre, and to actually comply with what the Legal Services Board says that we lawyers don't do well enough, which is to provide as wide a range of services as is possible to members of the public. Here, you might say, why are you telling us about PPI when the complaint scheme was closed in 2019? The reason is simple. Although the complaint scheme, which was all about mis-selling and nothing to do with the Consumer Credit Act, namely whether the product was suitable, whether or not the claimant was ever able to claim, etc., that scheme has closed and no longer can anyone make a complaint. But there is and has been no effect whatsoever on the court process. The litigation process is in effect completely unaffected by the complaint scheme. Now, you might also say, well, we all know that PPI complaints were ongoing for many years, and it's about 10 years actually before the complaint scheme ended. And what's left of the market? Well, interestingly, a great deal. What happened was, between 1990 and 2010, there were 64 million policies sold to members of the public. And by the time the complaints process date came, the end date, there were less than 50% of all policyholders who had been able to either put in a complaint or had been remediated previously. And whilst it goes beyond what I'm able to tell you today to explain why so many complaints or policyholders were still left unremediated today, part of the reason is the sheer numbers. The other part is jurisdictional. The complaint scheme, generally speaking, only covers loan agreements entered into on or after January the 14th, 2005. And as we know, policies were actually sold from 1990. So take it from me, the marketplace for those wishing to enter into this particular arena is, for all intents and purposes, infinite. The other good news is that we have the authority of the highest court in the land, so there's no longer any issues at all in relation to liability and success. Indeed, I've had the good fortune of handling several hundreds of these cases until I ceased private practice, and I can boast a 100% success rate. I say, with proper training and the proper application of principles that I've adopted in pursuing these cases in a cost-effective and efficient manner, that any firm or individual solicitor or freelance who wants to take on work within this arena, you should have a 98% success rate come what may. And that is probably higher than practically any other legal business model that any of us may have encountered over our career. Now, the next thing to inform you is that in order to be able to pursue these cases, one has to, of course, have a ready supply of cases, and because you will have to bring claims before the court in almost all cases, these claims do not settle by way of protocol. They do not settle because you've written a letter of claim. The reason for that is manifold, but the main one is the lending industry is well aware that more than half of the complaints that could have been made were simply not made for one reason or another. If they were agreeable to paying out on a letter of claim, then that would engender another claims management company entry into the marketplace. No, these are all reserved activities because we have to bring the claim before the court. You will find that in only 1% of cases issued will the claim ever go to trial. That's because the law is so much on our side, and although you will be facing defendant law practices who are really experienced, well trained, some of them are magic circle firms like Freshfields, others are silver circle national and international practices like Evershed, Simmons & Simmons, Rag & Co, etc. But have no worries, because with the right training, with the right supply of cases, with an efficient training to be able to bring these cases effectively, you will be generating a substantial and remunerative profit centre from these cases alone. And for those people who are doing road traffic accident work, we all know that the end is probably nigh. We don't know whether it's going to be definitely next April or some later date, but the legislation is in place, and many personal injury practices will feel a hole to some extent in their finances once the new whiplash regime is put in place. And I suggest that there's going to be very good reason for those people who do wish to enter into a different arena, albeit an arena where you don't negotiate the claims because the lenders make you actually present the claim to court, although rarely take you to trial. And the elements that are needed for any firm or individual who wishes to involve himself in PPI litigation are now well in place. We can direct you or signpost anyone that's interested to ATE cover, claims evaluation. The manner in which a claim is worked out is quite complex. You can't do it with a calculator. You do need a service to provide the claims value. And of course, on top of that's the training and all the rest of it, plus, most importantly, litigation funding. I say, because there are now several litigation funders that have entered the marketplace to help firms who have to pay on every case a court issue fee for starters, as well as carrying the costs of running the case until settlement, usually settlement, that this, along with there being several ATE insurers in place, this lends, if you like, approval, because commercial litigation funders, insurers would not make themselves products available within this marketplace if it wasn't perceived as being solid and likely to endure. The limitation provisions are incredibly generous. The last PPI policy was sold in 2010, and for reasons that I won't go into in any detail today, rest assured the limitation is not a problem, even if the loan was paid off more than 6 years ago. And there is established case law right up to the High Court and Court of Appeal in relation to limitation. So what we have here is something that's poorly served at the moment to members of the public, an arena, a legal arena in financial irregularities that is really almost ignored by most of the profession. To give you some understanding, when I won Plevin and then began to bring individual claims solely reliant upon that ratio of failure to disclose excess or substantial commissions, I was the only solicitor doing it for a number of years. Now that the end date for the complaints process has taken place, there are probably something like several dozen, possibly even 100 law firms, some of whom have come to us for assistance on training, but the marketplace is now, in relation to law firms, beginning to take hold. There's some traction, but the numbers are so great, the law practices dealing with this are still very small. So any of you thinking of becoming involved, you will still be in the vanguard for the bringing of these claims. Now, I mentioned that I have 3 separate business models to tell you about, all interrelated in one way or another. The second business model, again, arises out of a case in which I was personally involved for the claimant, in which there was PPI, although it's not necessary, as you'll see, for there to be PPI. There was a PPI loan which was brokered because there was a secured loan, and a broker charged the borrower a fee for introducing the borrower to a lender. And as you might all imagine, when there's a broker in place introducing the borrower to a principal, namely the lender, there's usually a commission paid, sometimes called an arrangement fee, sometimes called completion fee, but whatever, a payment is almost always paid by the lender to the broker. And under simple fiduciary rules, which we will all have some knowledge about, the broker, we say, is agent for the borrower. He's taken a fee off the borrower and he owes duties to keep the borrower fully informed, particularly in relation to a third party paying a fee additional to the broker fee that the borrower's paid. We found that the county courts were not sympathetic to this and rejected any elements of fiduciary obligations, so that the matter went to the Court of Appeal. The case in which I was involved is Matt William v Norton Finance, and there the Court of Appeal said it's straightforward. The broker in those cases, even though the broker agreed that it was an advice-only service, not providing any advice whatsoever, basically execution only, notwithstanding because it had taken a fee and because of the arrangements in place, that broker was held A, to be an agent for the borrower, and B, to owe fiduciary duties. So what we have in fact is a situation where the law in relation to PPI is established by the Supreme Court. The law in relation to other cases that may be brokered, which will be a minority, but you have a duty as a solicitor to bring all claims against the same lender within the same action, rather than bring the PPI claim and then try and claim the breach of fiduciary duty later. Again, we now bring all these claims as for fiduciary breaches as an unfair relationship, and the courts deliver the remedy just the same as if it were breach of fiduciary duty. And that basically gives anyone taking on these cases, if you like, the chance of not only bringing a claim for the PPI and the money to be repaid in respect of the charges and premiums, plus interest of course, but also to add in the fiduciary element, which will often increase the claim by a few £1,000s. Obviously, any claim that involves a breach of fiduciary duty type claim, because of a broker situation where they just never disclose the amount of commission, although sometimes they disclose the fact of commission, is likely, even if the claim value is well under £10,000, to put the fast track or multi-track as the appropriate track so that recovery of costs is assured. The third model I want to mention is brand new. The law in relation to remedy is our old friend, the Consumer Credit Act 1974. But what amounts to is the motor finance industry is subject to great deal of breaches of rules that you and I wouldn't know about. I didn't know about this until it was brought to my attention. And the reason it came to my attention was that the regulator, the Financial Conduct Authority, published, after a great deal of consultation and research, mystery shopping, they published final findings in relation to motor finance arrangements, which shows that the rules in force only since 2014, so we have quite a narrow window here. We have a window between 2014 up to date in order to bring claims. And let me tell you what the breaches, the fundamental breaches are, which have been discovered, which you and I wouldn't know anything about unless we'd managed to come into possession and read the final findings of the regulator. Each time we take out finance to buy a car, it's personal contract purchase in most cases, or PCP for short, the broker or intermediary, even if that intermediary is an appointed representative for the lender, is obliged by its rule book to disclose that the broker will be paid commission. And once that has been discharged, that information, he must disclose how much commission if requested. Now, the FCA in its findings did hundreds of mystery shopper experiences to gauge how the market is actually running. And it's systemic across the whole of the market that no brokers disclose even the fact of commission. But that's not the end of it. There's something else that really alarms the regulator, which is that in about 65% of all financed contracts, PCP or otherwise, the credit broker has a discretion to increase the interest rates so it will obtain higher commission. So alarmed is the regulator that it has brought in legislation effective from January 2021 banning these arrangements, allowing higher rates of commission for increasing the interest charge. The technical name given by the regulator is difference in charge arrangements, DIC for short, and DIC is being banned. Now, just to take you back to Mrs. Plevin, at one stage Mrs. Plevin's claim looked like it was going to fail, not her claim personally, but the ratio, because the Court of Appeal stated that even though substantial commissions, which were eye-wateringly high, were commonplace, How can there be any unfairness if there was no regulatory obligation to disclose commission? So in PPI, there was no obligation by the regulator, but the Supreme Court held it doesn't matter. Under the Act, which is to be considered separately to the rules, the court said there was unfairness, providing the commission was excessive or substantial. And you can take it from me, no policy ever sold is below the threshold for being substantial in terms of the commission earned. Here, motor finance, it's much better because there's an actual rule, and a fairly new rule brought in 2014, which requires disclosure of the facts of commission and then the commission itself if requested. Now, the FCA findings say they don't disclose either that we're going to receive base commission, they don't disclose this difference in charge arrangements, which applies in the majority of cases that I've mentioned. The great beauty of taking on motor finance claims, in addition to the other two, is that one actually helps to pay for the acquisition and marketing costs of the PPI. So for instance, if one perhaps has marketing arrangements where every 100 cases only leads to, say, being conservative, 30 good PPI claims within value, within jurisdiction, etc. Of the 100 claims, I bet you 10 or 20% are going to have a broker involved, so you've got a claim there on its own or an aggregate claim. And thirdly, probably every single one of those people, or most of the 100, if they're car buyers, they will have bought on finance, and they fall into the third factor, the third business model that I've mentioned. So we can point you in the right direction for those people interested in taking this further in terms of the training, in terms of the litigation funding, ATE cover, case supply, and evaluation of the claims values. And I say to those people who are perhaps quite impressed by the general legal arena that I've described, but perhaps have concerns that they've been involved in litigation for many years, they may have been involved in personal injury, and they may be used to settling cases rather than issuing them. And they may have an understanding that a reluctance because of the culture change that is needed. What I say to those people is, we are in evolutionary times. We have bigger and bigger commercial practices doing corporate work. The personal sector, the consumer, who is always being made a victim by financial institutions. And for the three models I've mentioned, the guilty parties are basically the lending industry. And all of these claims could have been avoided and would be avoided by simple disclosure of commissions earned on PPI, commission earned on loan brokerage fees paid by lenders. And in motor finance, of course, it's actually regulatory. And again, the regulator found that there was no compliance whatsoever, leaving things wide open. And as I say, those who are feeling somewhat reluctant because of the culture shock to become involved, I invite you to roll up your sleeves and basically lawyer up. Thank you, ladies and gentlemen. In a few minutes, I should be able to talk to you live for any questions that you have.